matter.
No,
The order of this honorable court where the questions were framed.
that was
like
the
a
questions
re-granting
framed by
order.
the court.
Yes, ma'am, but
We
the
are
court.
asking what about the questions which you framed in your reference for the opinion of this court?
That is in the reference.
My lord,
This honorable court also framed the questions.
Questions which were framed in the
This honorable court also framed the question, and it is a reported
I
matter.
think, Mr. Attorney General, why don't we just read the entire reference?
my lord.
And if there are sort of irrelevant or just factual things, we'll skip those.
Well, what happened was that after
Let's now
the
speak
reference was
headway.
filed, the questions were subsequently forwarded. I'll skip the language of Article 186 from page 1 and then I'll read. After the restoration of judiciary by the present democratic government, all the institutions of the state are adhering to the constitution and constitutional scheme of trichotomy of power. The judiciary in Pakistan is independent and is playing a proactive role in the cases of public importance. However, some important questions of law remain unanswered, and one amongst them is in waiting since long. This is the case of Zulfiqar Ali Bhutto, reported as PLD 1979, Supreme Court, page 38, decided in Criminal Appeals number 11, 12, and 13 of 1978, who is the founder of the Constitution of Pakistan, first elected Prime Minister of the country, leader of the Third World, Prime Minister of Non-Aligned Movement, founder of the Islamic Bloc, who took the initiative of introducing nuclear technology in the Muslim world. He was convener of the first Islamic Summit in Pakistan, which attracted unparalleled participation of leaders of the Muslim Ummah. Facts. In pursuance of wide-range conspiracy, Shaheed Zulfiqar Ali Bhutto was challened by the Federal Investigation Agency maliciously to face trial for offences under Section 120B, 302, read with Section 109, and 301, and Section 307, read with Section 109 PPC. The trial was conducted by the Lahore High Court in a highly objectionable manner, and he was judicially murdered. I, as the President of the Islamic Republic of Pakistan, in order to uphold the dignity of the court, supremacy of the Constitution and law, feel constrained to refer a few questions of law which are of paramount public importance and remain yet to be finally determined and answered by the Supreme Court of Pakistan. 1. The law of approver and criminal conspiracy is admittedly against the injunctions of Islam. The Holy Prophet, peace be upon him, on the occasion of Hijjatul Wada, pronounced, "Beware, every culprit is responsible for offense committed by him. Beware, the father is not responsible for the offense committed by his son, nor son is answerable for the offense committed by his father." Admittedly, absence of the accused from the scene of occurrence could not at all constitute personal liability. 2. Earlier, no accused had been convicted and sentenced to death solely on the testimony of an approver. The Honorable Supreme Court of Pakistan has again disapproved the testimony of an approver in the case of Mian Muhammad Nawaz Sharif versus State, PLD 2009, Supreme Court 814, and the law continues to be volatile. The testimony of the approver fails to satisfy both the tests in that he is neither reliable nor his testimony is corroborated in material particulars. 3. Intricate questions of public importance are involved in the matter. None is above accountability in Islam, and more so a qazi. Determination of the question of accountability, or at least a correction of error, amounts to introspective accountability. The democratic system of a country is dependent on the functioning of political parties. Leaders of political parties are repository of public trust and confidence. Their iconic image is an inspirational and motivational force for the followers. In the case of Shaheed Zulfiqar Ali Bhutto, this goes without saying that he was the leader who inspired generations. His charismatic leadership remains a role model for the toiling millions of Pakistan and the Third World, and his appeal for downtrodden is transcending through an annals of history. His totally illegal death sentence and his execution at the hand of tyrant dictators with the help of hand-picked judges is a black spot on the democratic face of Pakistan. 4. Whether the Supreme Court was acting within four corners of law while deciding the appeal by a bench, which was not duly constituted after the absence of two honorable members, namely Mr. Justice Wahiduddin Ahmed, who was shown sick, and the bench chose to proceed in his absence, notwithstanding the fact that he was desirous to join the proceedings, and Mr. Justice Kaisar Khan retired during proceedings. The Honorable Court was legally and morally duty-bound to fill the vacancies. 5. In the case in hand, bias in the minds of judges was floating on the face of the record. A bias in the mind of judge results in vitiation of the proceedings. In the celebrated judgment reported as Asif Ali Zardari and another versus the state, PLD 2001 Supreme Court 568, while dilating upon bias, the Honorable Apex Court held as follows, as under C. A judge may have a personal bias towards a party owing to relationship and the like, or he may be personally hostile to a party as a result of events happening either before or during the trial. Whenever there is any allegation of personal bias, the question which should be satisfied is there in the mind of the litigant a reasonable apprehension that he would not get a fair trial? The est is where there is a real likelihood of prejudice, but it does not require certainty. Real likelihood is the apprehension of a reasonable man apprised of the facts and not the suspicion of fools or capricious persons. 6. Shaheed Zulfiqar Ali Bhutto bitterly complained before the Supreme Court that he had not been given a fair trial in the High Court. As its presiding judge, Mr. Justice Mushtaq Hussain, Chief Justice of the Lahore High Court, and also because the Central Executive Committee of the Pakistan People's Party, presided over by appellant, had joined issue with him in respect of statements made by him, Mr. Justice Mushtaq Hussain, within brackets, in his capacity as Chief Election Commissioner in August 1977. 7. He strongly criticized the observations made by High Court in para 609 to 616 of its judgment, describing him as a Muslim only by name and not living up to ideas or conduct prescribed for Muslim rulers of Islam. Mr. Bhutto stated that this criticism was unjustified and was clear evidence of bias against him. 8. The conduct of the members of the bench holding the trial as well as deciding the appeal is fully demonstrative of bias. Mr. Justice Maulvi Mushtaq Hussain, the then chief...
Where is this said? Paragraph 609 to 616.
My Lord, this is in the Lahore High Court judgment, the trial court's judgment.
And the citation is?
My Lord, the citation is PLD 1978.
PLD 1978.
Lahore.
Lahore. Page?
Just bear with me, man. 1978, Lahore, page 523, sir.
523?
523. This was a 5-member bench of the Lahore High Court which was conducting the trial. 8. The conduct of the members of the bench holding the trial as well as deciding the appeal is fully demonstrative of bias. Mr. Justice Maulvi Mushtaq Hussain, the then Chief Justice of the Lahore High Court, Lahore, was known to be biased against Shaheed Zulfiqar Ali Bhutto due to being superseded. The entire legal fraternity and judicial community was aware of the temperament of Mr. Justice Maulvi Mushtaq Hussain, who never concealed his bias and hatred against Shaheed Zulfiqar Ali Bhutto. It will not be out of place to mention here that international community showed complete no confidence in the judgment in issue by defeating Mr. Justice Anwarul Haq for the slot of International Court of Justice, whereas Mr. Justice Dora Patel, one of the authors of dissenting judgment, was going to be elected unopposed, whose nomination had been withdrawn maliciously by the then caretaker government, who had come into power after toppling the democratically elected government of Muhtarama Benazir Bhutto Shaheed. 9.
Who was the Prime Minister in this caretaker government?
I believe it was Mr. Ghulam Mustafa Jatoi.
Are you sure?
1990, if I'm not wrong.
Was there any application made to the Lahore High Court showing no confidence in the then Chief Justice?
The record reflects that several applications were made. 9. Admission of former Chief Justice of Pakistan, Mr. Justice retired Naseem Hassan Shah, on print and electronic media that the decision of Shaheed Zulfiqar Ali Bhutto's appeal was under coercion does not leave any doubt in the mind of a sane and prudent person that it was a judicial murder which was decided and executed by dictator.
On what basis is this statement being made? Where is this admission?
My Lord, there were 2 interviews which were given by late Mr. Justice, retired Naseem Hassan Shah. One was, I believe, in 1996, but the other more recent one in 2009.
Have you filed the transcript of the interview?
My Lord, I have to file.
To whom?
It was given, it was a television interview which he had recorded, which he had given, and it was also reported in the press.
Which channel or which person?
My Lord, I will have to place it on record.
Mr. Farooq Naik, do you know?
Farooq Naik would perhaps know, but I'm aware that there was an interview.
Mr. Iftikhar of Geo News. Mr. Iftikhar of Geo News.
Iftikhar what?
Iftikhar Ahmed, I think so. Iftikhar Ahmed.
Iftikhar Ahmed, is he still in Geo?
Jawab De program. Jawab De program.
Is he still in Geo News?
He's still, I think he's still there.
And which is the other interview?
He's no. Jio mein nahi hai, but he's still here. He's still here. He's
And
definitely
which is
alive.
the other interview? You said there are 2 interviews.
Yes. There was this rather older interview.
Yes, there was a second interview he had given to an unknown person, जिसमें उन्होंने कहा था कि कहते हैं जो मार्शल लॉ लगता है तो हमें मार्शल लॉ वालों की बात सुननी पड़ती है.
One thing which you may want to make a start, making a note of these things. We would want, we'll pass an order, but we'll want to have these, whatever.
We will give the videos as well as the transcripts. My lord.
Exactly.
We'll do that. We'll do that. Thank you, sir.
So just make a note of
Yes,
this.
I made a note of it.
Did he mention that who has coerced him?
Pardon?
Did he mention that who has coerced him?
Who has coerced him? Yes. Well, he didn't. He just used the word martial authorities. Because the martial law, General Ziaulak was in power, and it was all orchestrated. The malicious design was orchestrated by General Ziaulak to execute Shaheed Zulfiqar Ali Bhutto.
You mentioned an application being filed by your client, but that was not filed by you, or was it filed?
It was filed by me, I think, in 2018.
Yeah, Biju filed ki, that's by Mr. Raza Rabbani.
No, my lord, I filed this at CMA in 2018. I'll give you.
No, now.
Now, अभी तो मैंने कोई फाइल नहीं की है.
No, for.
अभी मैंने खाली live stream.
You filed it, or Mr. Raza Rabbani filed it?
I filed it, my lord.
Okay.
And recently I filed an application for live broadcasting.
Okay. I was an impression that Mr. Raza Rabbani has filed.
No, I filed it, my lord. Thank you.
Ji, please continue.
From paragraph 9, my lord. This admission tantamounts to violation of constitutional oath of office which reads...
No, we skipped the oath.
Naseem Hasan Shah's book, Constitution, Law in Pakistan, pages
Constitution
52 and 53. Kindly read and everything will be very clear.
Okay. Constitutional laws.
His book is Constitution, Law and Pakistan Affairs.
And Pakistan, and published by?
Published, I do not know, but it's written by
Pages?
former Chief Justice.
Pages? 52, 50.
Pages are 52 and 53. And how this judgment was compiled, everything is written.
Mr. Farooq Naik, why are you so far away? We don't want to keep calling upon you or send some junior forward. And we would like this book to also, because he has referred to.
Can you read it?
No, we won't read it now. We'll let us finish the reference, but these things keep coming up, so we'll want to see the actual book. Please proceed.
This admission tantamounts to violation of constitutional oath of office which reads as under.
So skip the oath, we can move on.
As such, Article 6 of the Constitution of the Islamic Republic of Pakistan is fully attracted in this case. Next para.
Then there is a statement of Naseem Hasan Shah in Nawai Waqt, Justice Anwar Haq is इंतहाई मुश्किल हालात में अजीम फैसले किए नसीम हसन शाह.
So where are you referring to these things?
This is 2nd of March 19.
No, this paper book, what is in your hand?
ये मैंने फाइल किया हुआ है.
Okay, it's on the record.
It's on record.
Is there a number to it?
Its number is 57888-2011.
578
CMA 5788 of 2009 and filed on 31st of December 2011.
2011. Thank you.
Kasuri साहब, आप फॉर्मर चीफ जस्टिस नसीम हसन शाह साहब की स्टेटमेंट पर रिलाई कर रहे हैं?
नहीं, उसने अपना स्टेटमेंट
उन्होंने जो स्टेटमेंट
तारीफ कर रहा है जी सितत,
उन्होंने जो स्टेटमेंट्स दी
बल्कि
सुन ले
अपनी किताब में लिखा है अपनी किताब में लिखा है कि चीफ जस्टिस ने कहा हमें चारों जजेस को एक क्वेश्चन दिया कि अपने अपने जजमेंट देखो.
अच्छा, I think Kasuri Sahab, thank you for pointing this out. Attorney General, can you continue reading?
My lord.
Because
Paragraph 10.
yes.
It is important to point out that in Sindh High Court Bar Association versus Federation of Pakistan, PLD 2009, Supreme Court 789, while dealing with the cases of the judges who had taken oath under PCO, the Honorable Supreme Court at page 805 held as under. The judges of the Supreme Court of Pakistan, if any, the Chief Justice of the High Court, if any, and the judges of any of the High Courts, if any, who stood appointed to the said offices prior to 3/11/2007, but who made oath or took oath of their respective offices in disobedience to the order passed by a 7-member bench of the Supreme Court of Pakistan on 3/11/2007 in CMA number 2869 of 2007 and Constitution Petition number 73 of 2007 shall be proceeded against under Article 209 of the Constitution. The Secretary of the Law Division of the Government of Pakistan shall take steps in the matter accordingly. 11. It is also important to mention that Justice Ghulam Safdar Shah, who wrote dissenting judgment in the Supreme Court, was subsequently witch-hunted and ultimately he had to leave the country in a miserable condition. 12. Whether it was legally justified to award capital punishment to Shaheed Zulfiqar Ali Bhutto in the absence of any evidence worth name and merely on the basis of a totally cooked up and maneuvered story which never stood the test of routine cross-examination. 13. Whether both the Lahore High Court as well as Supreme Court were justified in awarding and maintaining the death sentence to Shaheed Zulfiqar Ali Bhutto on the basis of a so-called threat to complainant which was blown out of proportion. 14. All important cases bearing important questions of law become legal precedents for the time to come, and they are quoted as citations, whereas the case of Shaheed Zulfiqar Ali Bhutto is neither cited nor allowed to be quoted as a legal precedent by the courts of law. It is a judicial murder continuously haunting conscience of independent nation and legal-judicial circles and hierarchies. 15. The unconstitutional and illegal ouster of Shaheed Zulfiqar Ali Bhutto by a tyrant dictator and subsequent events was the root cause of initiation of an unprecedented criminal prosecution against deposed Prime Minister Shaheed Zulfiqar Ali Bhutto. It is a matter of record which has been evidenced through the public statements of the cronies of tyrant dictator that he wanted to get rid of Qaeda-e-Awam by all means. The use of judiciary for execution of his malicious designs should not remain part of our legal history, as this country has started treading the path of democracy under an independent and proactive judiciary which has shown its resolve to defeat and foil any attempt to undermine or subvert the Constitution of the Islamic Republic of Pakistan. 16. Was it not legal duty of the regime to conduct an independent and fair judicial inquiry into the incident before starting criminal prosecution against Shaheed Zulfiqar Ali Bhutto? 17. Was it safe administration of justice to award capital punishment to an accused of conspiracy for murder against whom the essential ingredients of conspiracy were not proved through reliable evidence? 18. Whether justice can be seen to have been done in this case while the appellant was deprived of his right of appeal before the High Court, being tried directly by the High Court. 19. Had he been tried by a sessions court, the trial judge would have been legally bound to follow the case law developed up to the time of trial, whereas the High Court ignored the same altogether. In this case, up to the time of trial and conviction, there was absolutely no precedent of conviction and sentence of capital punishment on the testimony of a prover. Neither in the judicial history of this country, murder trial of an accused was conducted by the High Court in its original jurisdiction, thereby denying the accused a valuable right of appeal before the High Court. The trial in this case was akin to the trial of Bhagat Singh, who too was tried, convicted and sentenced in Lahore on the testimony of a prover. 20. The judgment is per inquirium. According to Black's Law Dictionary, a judicial decision wrongly made is termed as per inquirium. The very fact that three honorable judges, Mr. Justice Ghulam Safdar Shah, Mr. Justice Dura Patel, and Mr. Justice Muhammad Halim, out of 7 gave a dissenting view, whereas 4 handpicked judges acted under the dictates of tyrant dictator, which makes it imperative for the Supreme Court of Pakistan to re-examine the law on the point of a prover and criminal conspiracy. 11. 21. It has been ruled by the Honorable Supreme Court of Pakistan in the case of Federation of Pakistan and others versus Mia Muhammad Nawaz Sharif, PLD 2009, Supreme Court 284 as below. Law is not a static object. It has to cope with the modern ideas and concepts and the disputes coming before the court for resolution, as a society with its environmental setup is continuously progressing. Law as well as its remedies are also changing with passage of time. 22. The question of bias needs to be revisited by the Supreme Court of Pakistan in the light of its judgment in the case of Asif Ali Zardari versus the State, PLD 2001, Supreme Court 685. 23. It was a split judgment of 4 versus 3. 4 convicting judges, that is Mr. Justice Sheikh Anwarul Haq, Chief Justice, Mr. Justice Muhammad Akram, Mr. Justice Karam Elai Chauhan, and Mr. Justice Naseem Hassan Shah, and 3 acquitting judges, that is Mr. Justice Ghulam Safdar Shah, Mr. Justice Dura Patel, and Mr. Justice Muhammad Halim, which needs to be revisited especially after the admission of more than one members of the majority view, judges who, as mentioned, minced no words in stating that the judgment was given under undue influence exerted by the government of the day. Whereas it is noteworthy to see views expressed by the dissenting members of the bench concerning the evidence of approval, which read as under. As the prosecution case mainly hinges on the evidence of the approver Masood Mahmood, the question arises as to whether he should be believed or not. An overall examination of his evidence has led me to conclude that it is not of the quality on which reliance can be placed. Not only that, it suffers from inherent weaknesses, but also tends to show that he was a man of conscience, which conduct is wholly unnatural in the background of the facts elicited in the evidence. This feature had opened the gate for the argument as to whether the alleged order given to him by appellant Zulfiqar Ali Bhutto to kill Ahmed Raza Kasuri and his own reaction to it amounted to an agreement within the meaning of section 120A PPC. However, this question has been resolved in the judgment of my learned brother G. Saftar Shah J, and I need not go into it. The High Court has construed the substantial omissions and improvements in his evidence as one of details or omissions of matters which have been brought on record by the public prosecutor by putting specific questions. In my opinion, these omissions and improvements vitally affect his truthfulness, and therefore in resolving it in favor of the prosecution in High Court, the High Court has given an illusory value to his evidence. If I may say so with respect, this was wholly unjustified. For the benefit of doubt in the evidence must in law go to the accused, as that is the elementary principle of criminal jurisprudence. 24. Accused is entitled to fair trial. Justice rushed is justice crushed. No murder in case in Pakistan right from the independence of Pakistan to date has finally been decided in such a short span of time as in the referred case. This unholy and extraordinary haste in disposal of this case also clearly demonstrates bias. 25. It is enshrined in the Constitution of the Islamic Republic of Pakistan that it is one of the prime jurisdiction of the Supreme Court of Pakistan to do complete justice. Article 187, Clause 1. The assumption of original jurisdiction by the High Court for trial of a criminal case is a question of law which needs to be determined by this court, particularly in the light of universally recognized principle and a fundamental constitutional right in Pakistan pertaining to the due process. 26. At the relevant time, the Evidence Act 1872 was in field and Article 164 of Qanun-e-Shahadat order was not on the statute book. The learned High Court, while conducting the trial in hand, did not take into consideration a material fact that prosecution was not in possession of any evidence of conversation between the approver and the appellant. Surprisingly, this fact was also ignored by the Supreme Court while appraising the evidence in appellate jurisdiction. 27. I may make it very clear that coalition government headed by Pakistan People's Party is neither interested in any type of vengeance against anybody, nor the government believes in revenge. However, unprecedented incident of judicial murder of an international face of Pakistan's twice elected Prime Minister and father of the first Muslim woman Prime Minister and the father-in-law of the President of Pakistan, also twice elected and the founder of the largest democratic political force of the Federation, cannot be left unchecked under the dictates of justice, fair play and history, hence this reference.
Now, can we go to the relevant orders that you were referring to?
My Lord, if my Lords may kindly turn to order dated 21st of April 2011.
G.
The President of Pakistan has forwarded the